Hello and welcome, Focus Learners. I am absolutely thrilled to have you here for this explainer. Look, if you're gearing up for your exams, you are in exactly the right place. Today we're going through the ultimate revision tool for understanding the English civil litigation process. We're going to take all those complexities of dispute resolution and civil justice, and we're going to break them down into really clear, digestible, and highly structured steps. The goal? So you can walk into that exam room with total, absolute confidence. Right, so here is our roadmap for today. We're looking at 1. The shift in civil justice. 2. Alternative dispute resolution. 3. Pre-action and issuing claims. 4. Case management and tracks. 5. Trial and post-trial. And 6. Efficiency versus access to justice. Let's get right into it.
Section 1. The shift in civil justice.
Okay, to really understand modern civil litigation, you have to realize that for decades, the system was overwhelmingly expensive, notoriously slow, and just incredibly adversarial. It was a system where the parties basically set the pace and the courts merely reacted. A massive paradigm shift was desperately needed. Lord Bingham brilliantly captured the core philosophy of this whole shift when he said that litigation should be conducted with the cards face up on the table. Basically, gone are the days of hiding evidence just to secure some sneaky tactical advantage.
Actually, the old system was colloquially known as trial by ambush, keeping your powder dry until trial. Today's system, which is governed by the Civil Procedure Rules, or the CPR, demands the exact opposite. We're talking pre-action disclosure, genuine cooperation between parties, and active case management by judges. The overriding objective now is to deal with cases justly and at a proportionate cost, saving expense wherever possible.
Section 2. Alternative dispute resolution, or ADR.
So, because of this huge push for efficiency and proportionality we just talked about, the courts now strongly encourage, and sometimes practically demand, that parties try to settle their issues before a trial even happens. The most common method? Mediation. This is where an independent third party, the mediator, helps both sides communicate to reach an acceptable agreement. Now, it can be evaluative, where they actually assess the legal strength of the case, or facilitative, where they just help define the issues. What you absolutely need to remember for your exams is that mediation is highly flexible and usually completely non-binding until both parties sign a written settlement agreement.
Next up is arbitration. Now, do not confuse this with mediation. In arbitration, an independent expert or a panel actually decides the dispute for the parties. The really critical distinction here is that the outcome of arbitration is a fully binding decision. Once the arbitrator makes their ruling, it is enforceable in the courts, exactly as if it were a formal court judgment. No backing out. Then we have early neutral evaluation, often referred to as ENE. Here, a neutral professional, very commonly a lawyer or a retired judge, hears a quick summary of each party's case and provides a non-binding assessment of the merits. This is incredibly useful, because it provides both sides with a realistic, highly objective baseline to go back and conduct further settlement negotiations.
And finally, expert determination. This is a process where an independent third party who is an absolute expert in the specific subject matter is appointed to decide the dispute, and their decision is binding. Think of highly technical construction disputes or maybe really complex financial valuations. You want a subject matter expert making that call rather than a judge who might not have that highly specialized background.
Now, what's really interesting about this slide is seeing both sides of the coin. While ADR is heavily favored by the system because, hey, it's faster, cheaper, private, and helps preserve business relationships, it is not flawless, and examiners want to see you acknowledge the drawbacks. Severe power imbalances can exist between parties, there are way fewer legal safeguards compared to a public trial, and in non-binding forms like mediation, well, there's no absolute guarantee of a settlement, meaning you might waste a ton of time and money only to end up in court anyway.
Section 3. Pre-action and issuing claims. Okay, so what actually happens when ADR fails, or when it just isn't appropriate for the dispute at hand? That's when we turn to the formal machinery of the courts. Every single civil claim follows a basic skeletal structure: pre-commencement, commencement, case management, trial, and post-trial. This 5-stage journey is your anchor for exam recall, so keep it in mind. Let's look at Stage 2, commencement. Here, absolute precision is required. Governed by Part 7 of the Civil Procedure Rules, you must issue a claim form that concisely states the parties, the nature of the claim, the factual and legal basis, and the specific remedy you're seeking. This is the document that officially starts the clock on the court's involvement. It's go time. Section 4. Case management and tracks. Remember how we said the old system let the parties dictate the pace? Not anymore. Now the court actively takes the reins, using an allocation questionnaire to assign a case based on its financial value and complexity. Small claims handles disputes up to £10,000. The fast track is for cases between £10,000 and £25,000. The relatively new intermediate track handles less complex cases up to £100,000. And the multi-track handles the really big heavy hitters over £100,000. Crucially, and definitely remember this for the exam, as of a 2012 Ministry of Justice directive, non-personal injury claims under £100,000 cannot even be started in the High Court. They must stay in the county court.
So, the absolute heart of active case management is strict procedural timelines. The court will issue directions, which are essentially orders detailing exactly when disclosure of documents must happen, when witness statements are exchanged, and exactly how cost budgeting will be managed. The courts impose these strict deadlines to prevent the unnecessary delays that used to just paralyze civil justice.
Section 5. Trial and post-trial.
Despite the system's absolute best efforts to settle disputes early, some cases will inevitably make it all the way to a final hearing. This is where meticulous scrutiny of the evidence happens. The trial involves opening speeches by the advocates, the presentation of witness evidence, intense cross-examination, expert testimony, and closing speeches. The whole thing culminates in the judge delivering a judgment on liability, quantum, which just means the amount of damages, and a detailed assessment of who pays the hefty legal costs.
But wait, what happens if, along the way, a party just ignores those strict calendar deadlines we talked about earlier? Well, the court will impose sanctions, which could literally include striking out their case entirely. If a party wants relief from those sanctions, the court applies the famous Denton test. First, they assess the seriousness or significance of the breach. Second, they consider why the default occurred. Third, they evaluate all the circumstances of the case to deal with the matter justly. The point is simple. The courts will no longer allow litigation to be unfairly derailed by repeated procedural failures. You've got to play by the rules.
Section 6. Efficiency versus access to justice.
Listen, if you want to secure a top grade in your exam essay, you can't just memorize the rules. You have to demonstrate high-level critical analysis. And the biggest debate in civil litigation today is exactly this. Does compelling ADR prevent a fair hearing? See, the English legal system is desperately trying to clear court backlogs and save public resources. But Article 6 of the European Convention on Human Rights guarantees the right to a fair and public hearing. So where exactly is the line between heavily encouraging efficiency and forcefully slamming the courtroom door in a claimant's face?
Let's look at the case law. Historically, the case of Halsey told us that penalizing a party in costs for reasonably refusing mediation was okay, but you couldn't outright compel them to mediate. However, the recent Court of Appeal decision in Churchill kind of shifted the goalposts, confirming courts can order parties to engage in mediation, provided it doesn't impair the very essence of their right to actually proceed to a trial. And overriding all of this is the Supreme Court's ruling in unison, reminding us that excessive barriers, like astronomical court fees, violate the fundamental rule of law by preventing access to justice. The law is constantly, and sometimes awkwardly, trying to balance this compulsory efficiency against your fundamental right to justice. So as court resources continue to shrink and mandatory ADR expands, we really have to ask ourselves, are we engineering a more efficient justice system or simply pricing the average citizen out of the courtroom entirely? Good luck with your revision, and think on that for your essays.